Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. I'm down at my Florida house today, and today we're going to talk about cliff diving. Well, sort of. Stay tuned. Did you ever look at a cliff diver and think, wow, how do you know you're good at that? It's like that ski jump that they have that's like 6 stories up, and then you ski and you jump and you glide for as long as you can. How do you know you're good at that until you survive doing it once? Today we're going to talk about risky investing. And by risky, what I mean is it puts your livelihood or your amount of money at full risk on a venture that might not always turn out the way you hope it will. So I'm going to look at tax foreclosures and explain sort of how those work and where the pitfalls are for your average person thinking, wow, I'd really like to buy some foreclosed beach property. In Florida, where I am at the moment, the tax sale process is somewhat convoluted in that you don't go to an auction and buy a property for back taxes. Actually, what you're doing is you're buying an investment venture that will get you 10% interest over the next 2 years. The process of buying the tax lien is quite simple. You register for an online auction, and at some point you pay more than you probably should for the back taxes. If the back taxes are $10,000, that's where the bidding starts, but that isn't necessarily where the bidding goes. But let's take the process where you have a $10,000 tax debt and somebody buys it for $11,000. What have they bought? Well, they've bought a lien on something that will earn 10% interest per year for the next 2 years. At the end of the 2 years, you can put the tax lien up for sale. Now here is where you really have an issue, because if the property is worth a lot of money, then you're probably going to make your money back. And you may even have a chance to get the property if you are the highest bidder. But the process doesn't always work to the benefit of the person holding the lien, because while there is a public auction to buy the lien to begin with, all that gives you is a right after 2 years have passed. You have to give the property only 2 years to reclaim the property, or knock off the lien essentially. And if he doesn't knock off the lien in 2 years, then what you have is an application to the county clerk for a tax sale. And then what happens is they hold another public auction. You get to bid, everybody else who's interested in that parcel of property gets to bid on that particular property. So they bid for the property, and let's suppose that you are the lucky bidder and you bid $300,000 for that property. Well, that gets paid and it goes into the registry of the court. Now, you paid for the original tax lien, so you've got $10,000 plus 10% interest over 2 years coming back to you before anybody else gets anything. But let's suppose the property went for $300,000. Now, anything above that, if there is a mortgage company, the mortgage company can claim on that. If the property owner wants to get that money, he can make a claim on it. He only has so much time to do it, but he can indeed get that money. But here is where an interesting quirk of Florida law lies. In between the date that the property is sold at auction and following the sale, you have until 11 o'clock the next morning to pay the money into the registry of the court. Any time between the time that the auction is over right up until the time the circuit clerk signs the tax deed, the property owner can come in and reclaim the property. And so, assuming that they got notice and all of the other things that are necessary, then you are going to be the owner of the property unless they come in and reclaim the property at the 11th hour. Most of the time that doesn't happen. But even though you now have a deed from the county that says you own this particular piece of property and you can dispossess anybody from that property, you still don't have clear title. And the reason you don't have clear title is because someone could still mount an objection after the fact. Let's suppose that the person who owed the back taxes got divorced, but his former spouse did not get notice of the sale. Not because of anything you did, but perhaps because of an error on the part of the clerk or an error on your part. Either way, they did not get notice, and they have a right to come in now and make a claim on the property. So even though you've gotten this deed, you're not home free yet. The only way to go home free is for you to affirmatively file a quiet title action. Basically, you hire a lawyer and they come in and they plead that you have clear title to this property and they ask for an order to make that so. They serve everybody who could have any potential interest in that property, homeowners associations, all kinds of people. And if nobody objects, if nobody comes in and says they have a superior title, then the court will usually quiet title to that property and boom, you own it. But now, in addition to the original investment of $10,000, plus your 10% interest and that sort of thing, you got the cost of paying an attorney and you've paid $300,000 for the property. Now, if it's worth $700,000, you're terrific. That's great. You've done a great thing. But if it is not worth that amount of money, then you haven't really done yourself very much good. Most of the time, people who have tax liens get their tax lien money back. In other words, they get the $10,000 and they get the interest. But usually there is a mortgage, and the mortgage company will come in on the tax foreclosure sale, the tax deed sale, and they'll say, we're going to pay the whole Megillah here so that we can have the property. And that's what they do. Then they foreclose the property, which gives them quiet title. It's really difficult to outbid a bank, particularly if the property is worth a lot of money. And that's particularly true in Florida, where there is property that's worth a lot of money. In addition to that, Florida has all kinds of quirky laws with regard to who has to get notice. Not only does the property owner have to get notice, but if your land adjoins a common area in a subdivision, then the subdivision has to get notice. If you have submerged land on your property, in other words, a pond, and that pond is also partially on a neighbor's property, then you have to give the neighbor notice of the property sale so that he can come in and bid if he wants to get the rest of the pond, right? There are all kinds of issues with this, and this is not something that you should do on a lark because it's a good way to lose a lot of money. What you should do is, if you're going to do this, you form an LLC and you do it like a business and you research the properties first and hopefully the solvency of the people who own the property, and then you can get the money back from them and go your merry way without having to go through all of this hiring of a lawyer and quieting title and all that sort of thing. It can be quite vexing to try and navigate that minefield without a lawyer, and I wouldn't recommend doing it. Now let's move on to Missouri. Missouri has a similar tax lien process. In other words, you buy from the county a lien on the property. So in Missouri, a county will usually give you 2 years of back taxes before they post a notice that they're going to sell the tax lien that they've placed on the property. In some counties, like Cole County, Missouri, where the state capital is, that is often a 3 or 4 year process of waiting before they put the property up for a tax sale. And generally what happens then is somebody comes in and buys the lien, much as they would in Florida. After the expiration of 2 years, they file an action to quiet title. So there isn't a second auction in Missouri the way there is in Florida. In Florida, there's first an auction for the lien, and then there's an auction for the property, which basically allows strangers who didn't even bother to invest in the property to come in and buy the property. In Missouri, the situation is different. Once you get the tax lien, once you have purchased that tax lien, then you can wait 2 years and you can file what's called the quiet title action, just like you can in Florida. And assuming nobody else has a superior claim on the property, you can take the property and dispossess anybody who is there. Now, these differ from mortgage foreclosures and things like that, which I can talk about in another video. Here is the real catch in Missouri law. After you get a quiet title judgment, in other words, you take it to the circuit court and the circuit court says, yes, you own this property. After you get that judgment, the original property owner can come back up to 1 year later and pay you what you have spent on the property and reclaim the property. So if you paid $10,000 for the tax lien and then you later filed the quiet title action and you got the property and you, for whatever reason, started to build or add rooms or fix the roof, do all kinds of things to make the property more livable, on the 364th day after you got that quiet title judgment, the original owner could come back, pay you everything that you paid for the property, including your costs on the quiet title action, and reclaim the property. That's what makes these so very risky. Other states have very similar laws to these, and the reason for these laws is basically due process. There has to be due process of law before you can take property from someone. And for example, the ways that this can be screwed up are legion. If you don't give proper notice, if you don't serve notice on all of the people who are supposed to get notice, if for any reason you misidentify someone and they don't get notice, if, heaven forbid, the person who owed the taxes is deceased, his heirs have an interest. And because his heirs have an interest, you may have to go to the trouble of trying to identify the heirs in that case. This can be a lot of work, and again, the return is usually not that great. So you have to be really careful about buying property at tax sales. The people who do this and do it well are people who understand the system and know what properties to look for. They usually have it down to a science as to what types of property to look for, what kinds of owners to go after, and that sort of thing. And that's how people who do this for a living make money at it. But even they would tell you that it is pretty risky business. So that's what I have for you today. Hopefully, if you have any questions, you can leave them in the comments down below. Like, share, subscribe, all the stuff we ask you to do. Thank you so much for watching. Have a marvelous day, and I will catch you down here again tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.